Welcome and thank you for joining part one of Seyfarth's micro webinar series, Partnering for Success, a cross-practice series on top legal considerations for government contractors. This installment of the series will address risks and opportunities in public infrastructure projects. All participants are in listen-only mode. You're encouraged to submit questions throughout the program using the Q&A feature in WebEx. However, if we run out of time and your question is not answered, our presenters will follow up with you directly in the days ahead. For those interested in CLE credit, an attendance verification code will be read during the presentation. Please write this code down. It will not be repeated and is required for CLE credit. Copies of the webinar recording and materials will be distributed to attendees following the presentation. At this time, I'd like to turn the program over to Amy Hong. Amy, you may begin.
Thanks, Dave. Good afternoon, everyone. My name is Amy Hong, and I am a co-chair of Seyfarth's Government Contract Practice. And I'm delighted that you're joining us for part one of our 30-minute micro-webinar series, Partnering for Success, where our government contracts attorneys team up with other practice groups to discuss a legal issue that impacts government contractors that crosses into both of those practice groups' areas of expertise. So our thought behind this is that your legal issues don't fit squarely into one practice group or another. So we're trying to provide content that doesn't either. So before we jump into today's program, I did want to give you a quick plug for the remainder of the series. So Dave, we can go 2 slides ahead. So these are the remaining topics we have. And as you'll see for each of these, they're all 30 minutes and all of them pair a government contracts attorney with another practice group. So we'll be pairing up with immigration, labor and employment, IP, corporate, real estate. So hopefully something for everyone. You'll all receive an invitation to the rest of the series. So be on the lookout for that as well. But now that we've jumped ahead, let's go back to today's program. We're really excited to introduce part one, which is a great example of the intersection between two practice groups, in this case, government contracts and construction, with the risks and opportunities in federally funded infrastructure projects. So next slide, please. And I'm joined today by 2 people, no better people to discuss today's topic. We've got first Erica Bakes. She is a counsel in the government contracts practice group here. She focuses on bid protests before GAO and the Court of Federal Claims, supply chain risk management, small business issues for government contractors, and most importantly for today's webinar, like me, Erica focuses her practice on federal grant requirements that apply when entities are performing projects that are funded by federal dollars. We also are joined by Chuck Wall, bringing us the construction law perspective. Chuck is a partner in the construction practice here at Seyfarth with a focus on advancing innovative ways to develop major infrastructure through non-traditional means, including public-private partnerships and design build. Chuck has advised both private and public sector clients on alternative project deliveries and procurement-related matters. And he also co-chairs the Transportation and Logistics Working Group. In short, Chuck is the perfect person to join us to discuss risks and opportunities in public infrastructure projects. Next slide, please. So just to tee up what the webinar is going to cover today, first, Erica is going to discuss what IIJA or federally funded infrastructure funding is, how it gets from the government and into the hands of contractors performing these projects. Next, Chuck is going to offer his construction perspective on how these projects might be structured and the benefits and risks of different infrastructure structures. Next, I will, with the 2 minutes we have remaining, I will go into the compliance obligations that are going to attach to these federally funded projects with a focus on Buy American requirements and other ethics and compliance obligations. So with that, I will turn it over to Erica Bakes to start us off.
Thanks, Amy. Next slide, Dave, please. Okay, so let's talk about the IIJA and where the funds from the law are going. So the IIJA has been deemed a once-in-a-generation infrastructure bill, and it comes with quite a big spending budget, approximately $1.2 trillion. Next slide. So far, $200 billion has been spent on about 20,000 awards for projects from the Golden Gate Bridge to road infrastructure in Texas to improvement of subway station access in New York City. Next slide. So in the IIJA, Congress has set funding priorities in 7 different buckets, which are described here on the slide. Each bucket received various amounts of funding, which then gets further subdivided among various agencies and even further subdivided into specific types of projects and specific types of funding. Next slide. As an example, Congress apportioned $50.4 billion to the EPA for water infrastructure. And of that $50.4 billion, Congress further specifically designated $15 billion for the Drinking Water State Revolving Fund, which provides lead service line replacement services. But even more specifically, half of the funds must be spent as grants and principal forgiveness loans, and the other half has to be made as low interest loans. Next slide, please. Okay, so now that we've explained how Congress has designated where all of the money goes, let's talk about how it ends up in the hands of contractors and recipients. So there are 2 different paths: competitive awards and non-competitive awards. Competitive awards refer to buckets of money that are designated for types of projects, but not for particular recipients. So they involve potential recipients actively competing for awards of a grant that is set aside for projects that meet various criteria. The potential recipients can be states, nonprofits, territories, and similar entities. Potential recipients submit a proposal, which the agency then evaluates and makes award. The recipient will typically then make competitive sub-awards in support of the project as well, which generally gets the money into the hands of contractors. On the other hand, non-competitive awards generally allocate funds for a specific type of project through formulas to specific recipients. Okay, so for example, for bridge infrastructure, there is a formula that Congress has set forth that distributes money among the 50 states, DC, and Puerto Rico, depending on the square footage of bridges that need repair in those locations, among other criteria. The states and territories then in turn take the money that's been allocated to them and decide which projects to fund, and typically make awards on a competitive basis in support of those decisions, which again gets the money back into the hands of the contractors. All right, so now that we know what the money is, where it goes, and how it is awarded, I'll turn it over to Chuck to talk about what this means from an infrastructure perspective.
Great, thanks, Erica. What I'd like to do is spend the next few minutes talking specifically about the funding that Erica described and how it's being used. And I want to start by focusing on the highways and bridges, which is the biggest bucket of money under the statute. And we're going to be looking at opportunities, the opportunities are presented and some of the risks that go along with that. So looking at the highways and bridges, I want to point out that while I'm focusing on this, really the same concepts apply to different asset classes, even though the percentages may be different, the dollar amounts may be different. So you can see in 2022, the amount of contract awards only for highways and bridges increased by 25% across the US. And that increase was reflected in 40 states plus the District of Columbia, and at least 29% increases in 25 of those states. And then looking at 2023, states have committed an additional $21 billion in formula funds up through the end of April. So with all those contracts in place, that is going to translate into increasing construction value in the months and years ahead. Next slide, please. So how are those contracts going to be procured? There's really 2 primary buckets, and they're not any different than the buckets, the primary procurement methods that are used for other funds. The first is the traditional design bid build, where you've got a public owner that will have the project fully designed, put it out to bid to qualified contractors, and then the low bidder is selected and builds the job. Then the second bucket is what we refer to as alternative project deliveries. And I've listed below some examples of those: design, build, engineering, procurement, and construction, which is like design, build, but sometimes with some more moving parts. Construction management at risk, public-private partnerships, and this is typically larger projects, not necessarily, but typically. And then as part of that, the public body is transferring an amount of risk or a category of risk that's typically not transferred to the private partner. So DBF, meaning design, build, finance, those are the responsibilities that are being transferred to the private party that's partnering with, whether it's a state DOT, a locality, or what have you. DBOM, design, build, operate, maintain, and design, build, finance, operate, and maintain is sort of thought of as a full P3. The bottom two categories are thought of as collaborative models, collaborative being between the public body and the private partner. So, and we'll get into that in a couple slides away, but usually that means front-end collaboration that's unusual and not a standard feature of the other procurement models. So if we could go to the next slide, please.
Chuck, before we go to the next slide, can I jump in really quick? This is really fascinating to me just because as a government contracts attorney, I feel like we're usually not getting involved until after this part has taken place. Are all of these alternative project deliveries, are all of these available in any type of infrastructure project anywhere?
No, that's a great question, because they are not. There's usually specific state legislation that has to authorize the use of these alternative delivery methods, and so they're not available in every state. Some states have had these in place for a while. I use P3s as an example. Virginia is a state that was an early adopter of that. They started in the mid-90s with legislation that's still in effect. And much more recently, within the past few months, Tennessee has passed P3 legislation. So there's a wide variety in terms of what's available in each individual state, and it depends upon what's been authorized by the legislature. Thanks, Amy. Glad you pointed that out. On the next slide, I had mentioned the more collaborative models. Well, actually, before we get to that, let me talk about some of the challenges and risks that come along with these projects. So the FHA has reported that for every $1 billion in highway and bridge investment, that's going to support 13,000 jobs, which is great. But the problem comes along with all this additional money and all these new projects being put under contract, labor shortages and difficulties in finding resources with respect to the engineering and design aspects is really leading to some challenges on the private sector. On the public sector side, the same applies. The responsibilities for planning these projects, for procuring them, and for overseeing the execution and doing the administration, many of them are a little bit behind the curve in terms of needing staff and expertise to move those projects along. So that is a challenge. Also, in relation to construction materials, we've all heard about supply chain issues and the volatility in pricing. And while that is smoothing out a bit, particularly here more recently on the pricing side, not completely. And so that continues to be both a challenge and a risk. And then mega projects, that's a bit of a different category. What I mean by that is projects that are, say, 250 million and up, and sometimes into the billions. And what we're finding is that the heavy civil contractors that are the ones who are capable of, the larger ones that are capable of building those projects, are becoming more reluctant to bid on projects that exceed, say, 250 or 500 million, just because of the inherent risks. And so that's forcing public owners to look at ways of either breaking up projects into separate projects or going about the procurement differently in order to get a full slate of competition, which is what they're looking for. Next slide, please. So here I'm coming back to the collaborative models that I mentioned, and that's progressive design build and progressive P3s. And I wanted to touch on 3 of the differences in these collaborative models versus the other models in basic terms. And you look at the first arrow on the left, the private sector team is involved earlier, they're chosen earlier based on qualifications, largely with some indicative pricing. And the opportunity is there for the public and the private sectors to engage with each other, to advance the design to a more mature stage before fixed pricing is established. So that's certainly a good thing in general terms. The middle arrow points to the reality that there is going to be obviously reduced price competition for that. And it's going to take longer to get to that fixed price. Now, there are off-ramps for those projects in the event that there can't be an agreement or the parties can't come to an agreement on pricing, but that's obviously going to delay the project significantly and overall is not a great outcome. And then the third arrow there, these projects, the collaboration model is intended to provide more certainty. And so a goal is significantly reducing the amount of change orders, being more precise in relation to the pricing, eliminating some contingency in pricing. So assuming a deal is struck, that's a good outcome for a project and a great objective. And so that's one of the things that's making those models become a bit more popular. If we could go to the next slide. So the IIJA included some things to promote the consideration by public owners of P3s as a potential tool, not necessarily forcing it upon them, but facilitating the opportunity to look at it. And I won't touch on all of these, but I'll mention a couple of them. Private activity bonds is a very useful way to finance a project efficiently. And a lot of projects in the P3 world rely upon PABs or would like to. And the capacity, the amount of bonds that can be issued was doubled by the legislation. So that's certainly an improvement. And also looking at the financing on the bottom right, TIFIA is a program that provides money at a very favorable interest rate that's attractive for P3s on the debt portion. And the legislation requires that projects over 750 million that are seeking TIFIA funds undergo a value for money analysis. And that looks at the different types of procurement options that are available and how those compare and what at the end of the day the value is for the money that's spent in terms of the project. So if we can go to the next slide, this is frankly another webinar. It shows the structure of the design, build, finance, operate, and maintain P3 model. And I'll touch on some advantages for both the public and the private sector. For the public sector, a P3 will almost always deliver a project quicker and sometimes substantially quicker. So while there are many other considerations that a public entity needs to consider, that is certainly one that is a benefit. On the private sector side, each of those green or blue boxes reflects a player in the project, except for the public owner on the right. So there's obviously a lot of opportunity on the design and construction side, on the long-term operation and maintenance, along with lenders and equity investors. So there's a very widespread opportunity that these projects present. And again, only if it's used on a project where it works, as opposed to being forced into that model. So with that, Amy, I will turn it over to you.
Great, thanks, Chuck. We can go to the next slide. Okay, so Chuck kind of talked about the ways that these projects might be structured. And now we're going to jump ahead to, okay, once the project has a structure, once you're bidding, once you've been awarded a contract, what are the compliance obligations that are going to apply both to the direct recipient, so maybe the state or municipal entity that actually received the funding, and then what compliance obligations are going to flow down to subrecipients or contractors that are actually performing the work. So next slide. We can go to the next slide. Thanks. So I'm going to touch on we're certainly not going to have time in 9 minutes to talk about all of the compliance obligations that are going to apply, but I'm going to touch on a couple of the big ones. And I think, one of the ones that people are most interested in and possibly one of the most material changes are domestic sourcing or Buy American requirements. So a lot of you might be familiar with Buy America, but you might not know that Buy America means different things in different contexts. So Buy America means one thing if we're dealing with contracts that are awarded directly by a federal agency that are governed by the Federal Acquisition Regulation. They can mean another thing if you're talking about a Department of Transportation project that has FTA or FHWA funding. And now, in the context of the infrastructure bill, it means something different for federally funded infrastructure projects. So we used to just have a kind of best efforts policy under federal grants for using domestic products where feasible. But with the passage of the infrastructure bill, we also got passage of the Build America, Buy America Act, which will apply to all federally funded infrastructure projects. That is even those that are not directly funded by the infrastructure bill. And they're going to require materials to be produced in the United States. Now, a couple of distinctions. This requirement is going to apply to materials that are incorporated into the infrastructure project, not necessarily materials that are just used to build the infrastructure project. So the simple example I always give is your hammer doesn't need to be Buy America compliant, but your nails do. So think about what is getting incorporated into the project itself. Then under the Build America, Buy America Act, you're going to have to consider what type of material you are actually delivering to the project, because there are going to be different tests about what is required to be considered produced in the United States. So if you're dealing with a manufactured product, then the test is your product must have at least 55% domestic content by cost. And by domestic content, I mean domestic component parts. And a component just has to be manufactured in the United States. So 55% domestic components by cost. And the manufacturing or final assembly has to occur in the United States. Now, in the case of construction materials, there's a slightly different test. As the bill itself states, all of the manufacturing processes must occur in the United States. However, that's a little bit of a misnomer right now, because under current OMB guidance, which was issued in 2022 to help agencies interpret these requirements, they clarified that for the time being, construction materials qualify as produced in the United States as long as the final manufacturing process and the immediately preceding manufacturing process step occur in the United States. However, we've had a proposed rule that's going to finalize what these requirements are. We don't have a final rule yet, but when we do have a final rule, it's likely to look a little more like the text of the bill itself and require all of the manufacturing processes to occur in the United States. And then in the case of iron and steel, all the manufacturing processes from the initial melting stage through the application of coatings must occur in the United States. So it's important to understand what bucket you're in, because the test might be different.
Amy, if I could ask you a question on that, how do you know which bucket you're in? If you're looking at manufactured goods and construction materials, how are you able to tell which bucket it goes in?
That's a great question, and a question that we get a lot because it's not just clear from, from the name, domestic or manufactured product versus construction material. The OMB guidance that was put out in 2022 has some helpful instructions on how to distinguish between a manufactured good and a construction material. It's not perfectly clear, but the OMB guidance contains a list of materials that HIT has designated as construction materials. So that includes non-ferrous metals, plastic and PVC products, glass, fiber optic cable, lumber, and drywall. Those are going to be construction materials. But if you're taking some of those materials and through a manufacturing process, combining them with other materials, then what started as a construction material might become a manufactured product. So an example they give in the guidance is if you just have a piece of glass, that's going to be a construction material. But if you have taken that piece of glass and created a sliding glass door with a frame and the other elements of the door, then that has transformed from a construction material into a manufactured product. And you're going to have to meet the manufactured product test, not the construction material test. It's a great question. It's something that comes up a lot. So before we leave domestic sourcing, which is a really important topic, there are a number of other supply chain considerations that we should think about under grant requirements. Erica, do you want to talk about any of the other supply chain risks?
Oh, sure. So one of the big ones that trips up contractors is Section 889 of the 2019 NDAA. Government contractors, private contractors in particular, will be familiar with this because it's a prohibition on the use or provision to the government of covered telecommunications equipment and services, which is from various companies, including Huawei, ZTE, and Hikvision. But that restriction also applies in the grant world. In grants, it's limited to the federal government's money can't be spent on covered telecommunications equipment and services. So when executing on these infrastructure projects, it's important to understand kind of where your supply chain is gathering any telecommunications equipment and ensuring that they're not prohibited. At the same time, there's also restricted party issues that could come up. So, of course, there's the economic sanctions restrictions, which restrict U.S. persons from doing business with various parties. And that the heavy lift there is the specially designated nationals and blocked persons list, the SDN list that OFAC, the Office of Foreign Assets Control, enforces. So to the extent you're dealing with foreign parties, you should be screening against OFAC lists, as well as the export control restricted party lists. So you can't provide any items to, for example, anyone on the Bureau of Industry and Security's entity list. So it's important to understand who you're dealing with. And then, of course, from a government contracting perspective, there's also the excluded party list, which relates to parties who have been suspended and debarred from government contracting, and that includes grants and non-financial assistance and benefits. So it's important to know your supply chain particularly well and make sure that you're complying with any obligations when dealing with your supply chain related to restricted party dealings.
Great, thanks. We can go on to the next slide. Okay, gratuities, bribes, and kickbacks, probably something that a lot of the folks on the line are already familiar with. Just note that these are going to apply to federally funded infrastructure projects as well. If you're doing a federally funded infrastructure project and you're an attorney, just know that 2 CFR Part 200 is where you're going to be living. And a lot of these requirements we see in typical federal contracts are also going to apply to these projects. It's probably something that everyone is already complying with, but it's just something to note and make sure that you have robust policies that are applying to federally funded infrastructure projects as well. Next slide. Bid rigging, inclusive bidding. Again, probably a familiar topic, but just a reminder that 2 CFR Part 200, which again is going to govern these projects, has non-competitive pricing restrictions, and inclusive bidding will violate those provisions. It's also important to note that these restrictions are going to apply at every level, from the recipient to the subrecipient to the lower tier supplier. And as a higher tier recipient, you should be taking reasonable efforts to ensure that your prospective contractors have not engaged in non-competitive pricing practices in responding to a solicitation. Next slide. Wage and hour requirements. Just note that the Davis-Bacon Act wage and hour requirements are going to apply to these projects. And I use this slide mainly as a plug because we're going to have a whole separate webinar series in the same series that deals with wage and hour requirements with some folks from our L&E group that is going to be in September. So stay tuned for more information on that. Next slide. Next slide. So we're at time, so I'm not going to list all of our best practices here, but again, we'll have the slides available. So please use these as takeaways. And then in closing, I will note that the CLE code is SS7478. Again, that is SS7478. And we greatly appreciate you for joining us for part 1 of this series, and we hope to see you back for the rest of the series. Thank you.